we can. And so when we talk about estate planning, really the threshold question for anybody is going to be, what is going to be the best vehicle for me and my family? In Arizona, and this is true in California, you're really looking at two different options. The first option is to use a will. And the idea with a will is you can direct where your assets go when you pass away. I think what's often misleading, though, is if you're actually using the will to distribute your assets, that means we actually have to go through probate court to handle the distribution of assets. A lot of people think, well, I would actually need a will to avoid probate. But the reality is the probate threshold in Arizona is really low. It's actually looking at $75,000 of assets, and that's an aggregate amount. So you take all of the assets, and if you're above 75,000 and that's passing through your will, we actually have to go through probate court. And so the tool that we use in Arizona to stay out of probate court is going to be known as a revocable living trust. And so I think it's important when we talk about a trust, because a lot of people, you know, on this call tonight, you know, I'm sure you guys have heard about a supplemental needs trust or a special needs trust. And that's really going to be a different type of trust when we're talking about estate planning. And so I always like to explain the fundamentals first. And so the trust, and this is true for every type of trust, whether it's your revocable living trust for your estate plan, or whether we're talking about a special needs trust, which we'll talk about later tonight. But every trust that's out there is always going to have three different parties to it. And so as Jenna knows, I'm not a very good drawer, but I like to use diagrams when I'm trying to explain this, because I think, you know, people can talk in legalese and it doesn't make much sense. So I like to use diagrams. So what I'm going to do is I'm going to get a diagram up here and I'm going to share it with you guys. So hopefully from your computer, you'll be able to see my screen as I go through it. And so I'm going to pull it up here, and then just let me know if you guys are able to see it okay. All right, and then are you guys able to see the whiteboard on your guys' screens?
Yes, I can.
All right, so yeah, so what we'll start with is really the foundation of your estate plan. And so this is where we talk about the revocable living trust. And so I use a triangle to illustrate the trust because, again, the trust itself always has three parties to it. And so here we'll be talking about the revocable living trust. And so the first party to the trust is what we refer to as the trustor. And so really that's just the legal term that's referring to the creator of the trust. And so when you're setting up an estate plan for your family, you're actually the creator of that trust. And so as the creator, you're able to design the trust however you want. And because it is a revocable trust, that just means that you can change it at any time, which is important because we know over time things are going to change, whether it's assets or the family circumstances. We always want to make sure that everything is up to date. And then the second party to the trust will be known as the trustee. And then that's really just the legal term that's referring to the manager of the trust. And so when you set your trust up initially, you will actually start out as the initial trustee. So you're maintaining full control over all the assets that are in the trust. And then the third party is going to be known as the beneficiary. And so during your lifetime, you'll actually be the lifetime beneficiary of the revocable trust. And so when we're dealing with special needs, it's very important on that aspect, because as you've gone through the process, or you eventually will, they're going to start asking about resources of your children. And so on the questionnaires, they're going to be asking, you know, if your son or daughter actually is a beneficiary of a trust. And so when you have the revocable living trust, the answer is actually no, because as long as you're alive, you're still the beneficiary of the trust. So we're not having to disclose this on any type of resource application, which will be important. It makes your life much easier. And so as we go through the trust tonight, what I like to do is just to break it into phases, so that way you can see how the plan is set up, and then most importantly, how it plays out in the future when we get into the what if scenarios. So the first phase, and this is true every time that you're looking at setting up an estate plan, is in order for this to work properly, we need to make sure that all of your assets actually get titled into the name of the trust. And so when we talk about phase one, it's really the funding itself that we want to talk about. And really, we just start with the general rule that for any asset that actually has a documented title, so real estate, bank accounts, life insurance, brokerage accounts, retirement accounts, businesses, anything that you have that your name is on, we need to get that into the trust in order to stay out of the court system. And this is truly the most important part of setting up your trust. And it's even more important as the years go on. And because we know things are going to change, assets are going to change, you're going to buy new vehicles and stuff like that. So when we're helping you in setting up the trust, we're really taking a snapshot as to the current assets that you have and working together on transferring those to the trust. And then anything new going forward after the trust is set up, you can just take title in the name of the trust. So what we do for our clients is we actually will provide you, we call it a trust ID card. So it'll actually have the name of the trust on there. So like the best example, if you go buy a new vehicle, you can just purchase it right in the name of the trust, and then the title itself has the trust on there. And so yeah, the funding itself, I know tonight's focus is not on that aspect of it, but just in general, for anybody who has an estate plan, I can't stress enough, in order for it to work properly and to stay out of the courts, that funding has to be completed on the front end. And then as things change over the years, we need to make sure that everything stays in the trust. And so, yeah, we usually recommend meeting at least once every 3 years to just review the funding to make sure everything is up to date. And so the reason that the funding is so critical is when we move into phase two, and when we start to now talk about urine capacity planning. And so this is going to be especially important because the reality is, as we get older, there's probably going to become a time where we're going to need help paying bills or managing assets. And unfortunately, in my practice, I also see worst case scenario where it could just be a car accident or something that is really not anticipated, where now one of my clients is incapacitated. And so now they need somebody to step in to make sure that they're taken care of. And not only that they're taken care of, but also that your children are taken care of. So if we put that into context, if something happens to me, you know, who's going to step in and make sure that my daughter's taken care of and making sure that her needs are met. And so when we talk about incapacity planning, the easiest way to think of it is you're really going to have 3 different tools that work for you. So the first tool is the trust itself. And so for everything that you title in the trust, you as the trustee, so if you're an individual, it would be you, or if it's husband and wife, then husband and wife would be both the trustees at that time, then you have full control over everything that's in the trust. So at this point, we're only talking about in the event that there's something that happens to you where we need help with managing the trust. And so that role is going to be known as your successor trustee. And so the successor trustee in this phase is really the individual who's going to step into your shoes to make sure that you're taken care of and that the assets of the trust are taken care of. And so this is always a very difficult decision when I'm sitting down with my clients as far as who that trustee should be. And so it certainly does take some discussion and some thinking, but really at the end of the day, I would say my advice there is, as long as it's somebody that you know and trust, it could be a loved one, it could be a family member, a son or daughter, parents, siblings, or it could just be a friend on the street. As long as you know and trust that they're going to follow your directions in the trust, the reality is they don't have to be really good with finances or anything like that, because they can always hire people just like you and I can. So if they need help with taxes, they can hire a CPA. If they need help with finances, they can always get that help. But as long as you know and trust that person, it's going to make it much easier to have that peace of mind that somebody's going to be there to make sure you're taken care of. And so that's really the first tool that we have for incapacity, or what I'll label as 2A, and that's who's managing the trust. Along with that, we also always do what's known as a financial power of attorney. So financial power of attorney, and you guys may have heard of this before. A lot of people refer to this as either a financial power of attorney, or some people call it a general power of attorney or a durable power of attorney. The reality is it all means the same thing. It's really just a power of attorney that's meant to deal with assets that are outside the trust. So let's put it into context. So let's assume that you're going to name your son as the successor trustee. So then in that case, if now all of a sudden your son needs to step in and pay the bills, well, your bank accounts will be in the trust as part of the funding process. So now your son will have access to your bank accounts. So he'll be able to write a check to pay those bills. But now if he calls a third party, so people that are in Maricopa County, so now they call SRP to pay the energy bill, well, your son's name won't be on that account. So that's where they'll have to show a financial power of attorney to speak with somebody like a utility company. And if you're dealing husband and wife, I see it all the time where husband or wife calls, but the account's in only one of the spouse's names, so they have to speak with the husband or the wife. And so this is where you can actually list husband and wife as the primary, and then whoever the successor trustee is as the backup. So that becomes especially important if your spouse is out of town and now all of a sudden we need to deal with something immediately. So between your successor trustee and your financial power of attorney, that'll cover the management of your assets during an incapacity. And then the third tool is going to be everything for healthcare purposes. And so this is actually where it gets very state specific. So for those of you who are listening from California, this will be different for you. But in Arizona, they really break it into 3 different components. So for healthcare, the main piece that we'll probably always think of is going to be the medical power of attorney. And in Arizona, we actually have a separate mental health power of attorney. From your perspective, it's really the same thing. It's just where we're saying, okay, if I make decisions for myself, I'm designating a third party to make those decisions. And so that'll be handled in the medical power of attorney, which would also encompass your mental health power of attorney. And then along with that, the supporting components that I always refer to is first is going to be your Hipaa authorization. And this is really just the document we have to sign every time we go to the doctors nowadays. It's really just going to be authorizing your doctors and hospitals to communicate with whoever you've named in your medical power of attorney. So that way, if they need to make decisions, they can actually speak with the doctors to get the information so they can make that decision. And then the third component for healthcare is referred to as a living will. So the living will, and I always like to take time to explain this too, because a lot of times I'll have clients come in and they say, as soon as I say living will, they say, oh, do not resuscitate order. I know exactly what that is. And so I'd always like to take some time and explain the differences between that. So the living will is really where you're saying, okay, if 2 doctors certify that I'm in a persistent vegetative state and there's no medical probability of coming back, then at that point, I don't want to be kept alive artificially. And the key there is I've had now 2 doctors evaluate me and certify in writing that there's no chance of coming back. So this living will became, I would say, well known, and it was based out of a case out of Florida, the Terry Schiavo case, where husband and wife had discussions amongst themselves. And then when the wife went into a coma, you know, the husband knew what his wife's wishes were, but the problem was she never did a living will. And so at that point, the wife's parents came into the picture and wanted to keep her alive. And so it became just a really ugly court battle. And so this is where the living will can be done if it reflects your wishes. And I really do mean that. It's not for everybody. It needs to be very specific to you. And then when we compare that to a do not resuscitate order, I always like to use just a real life story. So I had a client, she was only 62 years old, perfectly healthy. But yeah, she had went to a neighborhood event and they were talking about, do not resuscitate orders. And she ended up filling one out with her physician and put it on her, it was actually on her freezer at home. And so if you've seen them before, they're actually on an orange sheet nowadays. But that's really the do not resuscitate order. And what that's saying is you really don't want any medical help. And so what happened for my client is she had bumped her head while she was home and her neighbor found her. And so when the neighbors called the paramedics, they wouldn't do anything to help her. So even though she was unconscious at the time and they could have saved her, because of that do not resuscitate order, their hands were really tied. Well, she ended up passing away, and the children just, having to deal with that. They, really, I think what it was and what the children were telling me is she didn't realize that's really what the do not resuscitate order did. So I would say for the majority of my clients, unless they're going to be terminally ill, or like my grandmother who's 99, most people are not going to have a do not resuscitate order in place just yet. Usually that would come down the road, once you make that decision. But I always like to spend time on that because after seeing that happen to one of my clients, I think it's important just to be educated on that so you can make the right decision for yourself. So yeah, kind of putting it back into context. So here we are in phase 2 dealing with your incapacity planning. So your first tool is the successor trustee, and that's really the individual who's managing the trust for your benefit. Second tool is your financial power of attorney. So if your successor trustee has to deal with third parties like utility companies, Social Security, credit card companies, they have that authority. And then for healthcare, that'll be everything that you need for medical purposes. So yeah, that's really focusing on your incapacity planning. And now we're going to really jump into the details where we deal with the special needs planning. But before we jump into that phase, is there any questions that anybody has now that they'd like to tackle before we move on? Well,
And remind them to unmute themselves if they do.
yeah. And also too, if stuff comes up as we come through this, feel free to interrupt me and ask the question.
I have a question. My name's Jenny Gonzalez.
Yeah.
And I have a trust in place now that I've updated last year, I believe. No, actually, it's been a couple years because Elijah was included, but as baby boy, because of course he wasn't born yet. So, so, I mean, I don't know how that's gonna. Plus, I don't know, like all these other details. We didn't go into, all these details that I'm now paying attention to, and so is it updating all over again since he was listed as baby boy, or?
A lot of times, like in trust that I would do where you're having after-born children, we would automatically include those. Like I was telling you about the Kobe Bryant issue. I was really surprised that that wasn't in there because typically you would provide for after-born children. So yeah, I would just need to see the provision in your trust. And so, yeah, I'm happy to look at that for you to explain it to you.
Okay.
Hey,
Thank you.
can I say something, Jeff?
Yeah.
I know 2 parents who their families meant well, and they put a trust only in their child's name. The dad died, and all the money went to the 2 boys that we love, and that has created so many problems, So, Jenny, I highly encourage you to go and talk to Jeff in person because there's just a whole bunch of stuff that I won't take up time now to tell you, but I can tell you later. But anyway, go back to you, Jeff. Thank you.
Okay, thank you. And thank you, Jenny, for the question. It's a good question. So Now, when we get into phase 3, so the easiest way to think of this is going to be essentially the death of the trustor. And so in this case, really we're looking at two situations. One is, so if you're a single parent and you're setting up the trust, then you would be the sole trustor. Whereas if there's two of you setting up the trust, then you would both be trustors. So now that you've passed away, now we're talking about, well, what happens to the assets of the trust? And that's one aspect. The second aspect is going to be also who the children live with. And that's going to be very important. And so if you haven't gone through it before, eventually, essentially when your child turns the age of 18, if your child has a disability, you may have to go through a very unpleasant guardianship proceeding where you would essentially have custody now once they turn 18. And I know it's just a terrible situation to go through and very unpleasant. But then now this also becomes a question now, even if you've obtained guardianship now that your child's turned 18, well, what happens if you pass? And so as part of your estate plan, you can actually designate a successor guardian who would step into your shoes. And so the guardian itself is always going to be necessary if you have a child under the age of 18, or if you have an individual with a disability who's over the age of 18, then you would also need the guardianship as well. So in this case, we're going to deal with two aspects, is the guardian. And the guardian is really, you can just think of it this way, the guardian is the person who your child will live with. And so that may be the same person or may be different than the person who's going to manage the assets for your child. So at this point, what a lot of people think of, and this is true with a lot of wills and trusts, is typically it says, okay, if I pass away and my children are over a certain age, sometimes you'll see 21 or 25. If they're over a certain age at that point, we're just going to distribute assets to them. So effectively, if it's a will, the probate court will just distribute those assets, or if it's a trust, the trust distributes those assets. Well, the problem we see on the back end is we're administering this trust is stuff may come up in the individual's life. So let's assume that we're dealing with an individual with a disability. Well, we can't have those assets be distributed to them individually because, one, it becomes a resource of theirs. And so as a lot of parents do, they spend many years trying to get the appropriate health care for their children. And you have to jump through so many hoops to get that proper care. And so I've seen it firsthand where now I'll have a parent pass away, and if the safeguards aren't in place, and now all of a sudden money is going to that individual, now it becomes a resource, and now they're kicked off of their benefits. So now they're back at the starting point. So effectively at that point, if they have resources in their name, now they effectively would have to spend down that money before they could reapply to receive benefits. And then you're starting all over, especially for the healthcare side of things. So this is where, from an estate planning perspective, we can prevent that from happening. And so one way to think of it is we'll compare essentially what I call distributions versus allocations. And so the key here is we never want assets to be distributed to your child, because now they become exposed. They essentially will be considered a resource. So what we want to do is we want to keep these assets in trust, where now they're not considered a resource, and also now you can have somebody that you know and trust oversee the money for your child. So now let's assume in this case that we're talking about dealing with your daughter. And so let's assume your daughter has a disability, and so at this point we don't want her to actually have resources in her individual name. So this is where we can create what's referred to as a supplemental needs trust. And some people refer to it as a special needs trust. It really means the same thing, but I'll refer to it as a supplemental needs trust because I think it's easier conceptually when I explain really what it's doing. So we go back to the foundation and say, okay, now we're dealing with a trust. Well, it does have three parties, just like when we talked about the revocable trust up top. So now at this point, the parties are going to change. And so let's assume, so now the trustor or the creator of the supplemental needs trust will actually still be you, because you're creating it as part of your revocable trust and you're using your assets to fund the trust. But now that you've passed away, we need to find an individual to serve as the trustee. And then that's really going to be the key point. And now at this point, the trustee is the one who's going to oversee the assets for your child. And then on the beneficiary aspect, now your child is identified as the beneficiary. So what this trust does is it allows you to set aside as much assets as you want for the benefit of your child. And that's key, because right now the resource limit is very low. You know, it's approximately $2,000 that they would be allowed to have in their individual name before they're disqualified from receiving benefits. So with this structure here, you could literally have millions of dollars sitting in this trust and not be considered a resource. And that's why it's so critical that when we pass assets on to individuals with a disability, we want to make sure that they're protected, and the supplemental needs trust is that vehicle that we use to protect it. And so what a supplemental needs trust is I think the easiest way to explain it is it's just meant to supplement what the government is already providing. So, you know, generally speaking, the government is supposed to be providing food and housing as well as healthcare benefits. So the supplemental needs trust is meant to supplement that. And so it could be something as simple as, you know, now your child needs to get a haircut, they need to get a new TV, they need new clothes, or let's assume that they need additional money for health expenses. And so effectively, this supplemental needs trust can be used for a variety of purposes. And what's really nice about the supplemental needs trust too, and we'll talk about the ABLE account in a minute, but the supplemental needs trust, when it's created this way, no matter what the assets are in that trust, when the child passes away, the state cannot actually come after the money that's in that trust. And so the reason I point that out is the ABLE account, which was enacted several years ago, but just recently was actually implemented here in Arizona, has become another tool that we use for special needs planning. But one of the main downsides that we have with an ABLE account is the money that goes into that account is going to be subject to the state, meaning that if the state has provided any type of benefits for your child, then they can actually take the remaining funds in that ABLE account. Whereas with this type of supplemental needs trust, that's not the case. It remains protected, and then you could pass it on to your other children or loved ones. So the supplemental needs trust is kind of that first aspect that we have to deal with as far as who's going to manage the assets, who's going to make sure those assets are taken care of for your child's life. The second part is going to be the guardians. And so with a trust, you always do what's known as a pour-over will. So the pour-over will itself, you can think of as more like a safety net. And the safety net aspect is the pour-over provision. So we talked about the funding, and the reason it's so important that we get everything into the trust is as long as everything's in the trust, we don't have to worry about probate. But what we do in the will is it's a safety mechanism, just saying, okay, if there's anything outside the trust at the time that I pass, the will would transfer or pour those assets into the trust. And so now at that point, you still may have to go through probate if the total value exceeds $75,000. So that's why I always tell my clients, we do the pour over will, but we never want to have to use it because there's a risk that we still have to go through probate with that will. The second aspect that we're going to deal with is the guardians. And this is very critical because, again, we go back to who the guardian is really who your child's going to live with. And so now as part of your will is you can now designate who you'd want to be the guardian of your child. And that's usually the most difficult decision for any parent. And it really does take a lot of thinking as to, essentially who would actually step in to take care of your child. And so at this point, it's always hard too, because when we look at the trustee of the supplemental needs trust and the guardian, it may or may not be the same person. I have certain cases where clients say, you know what, I trust my brother, I trust my friend. They would manage the finances well, and they would do a great job raising my child. I want them to do both. And then I have some clients that come in and say, you know what, I love my brother, my sister-in-law, they are great people. They would do a great job, raising my child, but they are absolutely terrible with finances. They've, filed bankruptcy. They live paycheck to paycheck. I don't want my money to essentially be squandered away. And so at that point, now you could consider a third party serving as that trustee. So now you have the peace of mind that the money's taken care of, and then also that your child's going to live with the best person. Okay. But yeah, that's kind of going to be the general overview when we get into the planning on the back end, as far as who manages the assets and then who our children are going to live with. And so, yeah, I think this would be probably a good time to open this up for questions. And if you guys just want to unmute yourself as you want to ask questions.
Jeff, sorry, my clock is chiming as I unmuted myself. Sorry about that, you guys. I can't tell you guys how much I loved Jeff and James helping. It just opened my eyes to things. And for one, like he mentioned with the ABLE account that they're calling a stable account, I can't emphasize enough why I don't feel good about those, because we all pay taxes and, we're all grateful to do it. But when your child dies, the state gets all your money. I don't like that. But I wasn't familiar with your pour over will. Help me understand, Jeff, what that was. That didn't ring a bell to me.
Yeah, so when you're doing a trust, the whole purpose is to get those assets that you own into the trust. But what we do as a safety net is that pour over will, where we just say if there's anything that's not in the trust at the time that you pass, the will would transfer or pour those assets into the trust. So it's more like a safety mechanism. So for instance, if you forgot to put a vehicle in there, forgot to put a small bank account, we can use the will to get it into the trust without going through probate, as long as it's below $75,000. And then the pour over will is also where you include guardian designations for your children. And so when we talk about the special needs planning, that's really the most important part, is the guardian designations.
Okay, that makes sense. One of the things also to the families listening that I appreciated, it used to be like when he's 37 now, but when David was little, we would have to write our will for other 6 children or our planning, and they get money, but David gets nothing. And we hope that one of our kids is nice and will take care of him. But I'm so grateful that the laws have changed. And so now all of our 7 children, our assets are divided equally. But there's a good chance David will pass before his siblings, which, sorry, boy, I'm such a mom, but that's the hard part for me. But what I appreciate is that if he does pass before them, the state won't get the funding and it would go to our other children. So I'm really grateful for that. Okay, I'll be quiet and now you other cute parents can ask stuff.
Jeff, this is Charla Hank. And I know that things are different here. We actually have a trust, but you're reminding me, and it's always in the back of your mind. So we are one of those parents I will share with you guys. We actually started ours back in 2009 after my in-laws had passed. It's sort of, it's always one of those things that it's a reminder that you need to have these things in place. When you see, when we saw his brothers, my husband's brothers going through all of this, and it was definitely a reminder of what we wanted to do and to have set up. But have we gone back to update it at all? No, we have not had any additional children, but there are other things, that have transpired, or, I keep thinking, oh, that document's in the safe. I haven't looked at it for such a long time. Am I even talking to those same people maybe that we put in there? Because we were very, very meticulous about ours. I think we drove the attorney a little crazy. So I think we've got all this in there except for now with the ABLE account. So My questions are more, thank you, by the way, this is so beautiful. I did have to take a picture. I hope that's okay, because you did it. It's so easy to understand for someone that hasn't done it for many, many years. And for me to maybe say to other parents, like, hey, you need to go and talk to, I wish you guys were here. I wish you had a practice here. But you need to go and talk to someone, and this is what you need to make sure that you have. And if you don't, you need to update that. But with the ABLE account, we did open an ABLE account here, but with very little in it. And now I'm second guessing that a little bit, we know that the state could take that, at some point, but knowing that we're not going to keep much in there, it's really just for him. I don't know. So I'd love to hear your thoughts on that, or anyone's thoughts.
Yeah, actually, I'll share something with you. Jenna, we're recording this, right?
Yes, we are.
Okay, so I'm going to talk in hypothetical terms.
Yes, please.
So what's kind of a glaring loophole in the ABLE account is, so if we look at a supplemental needs trust, so that the trust itself is meant to supplement what the government is providing. So let's assume that, your child needs special housing. And so the government's only going to pay, say $2,300, it's about $2,300 a month. That's what they're going to give your child for food and housing. But really the need is $5,000. Well, typically, if you're paying it out of the trust itself would essentially lose that benefit. So that $2,300 a month that was coming to you, you would effectively lose that, and you would still be able to preserve your benefits for healthcare and so on. So what the ABLE account has now allowed us to do is really get around that, because now let's assume we have just simple numbers. We have 100,000 sitting in a supplemental needs trust, and now we go open up an ABLE account.
Thank you. I have to write this down as well.
No, and
okay.
so this is good that you've already opened it. I actually tell all my families to at least open a small account, because
okay.
the ABLE account, and kind of give you a history. So the ABLE account is really, it was derived from the 529 accounts that they have for education. So what Congress realized is, well, individuals with disabilities aren't going to have the same educational needs. So we need to do something to fix that. And so that's where the ABLE account was passed, which is a great tool. And so it really piggybacks on the 529 account, meaning that the money that's in an ABLE account grows income tax free, just like a 529 account. The problem, and I hope they eventually fix this, but the problem is like Jenna was saying, is, some people will look at that and say, well, geez, I'm going to dump all my money into an ABLE account. It'll grow tax free. And now we have, a nice nest egg there. But now it's subject to the claims of the state. So now if all of a sudden your child is receiving care during their life, well, whatever's left in that ABLE account can get taken away from them. Whereas with the supplemental needs trust, that's not the case. Whatever's left in the trust can go down to your other children. So the ABLE account has kind of become that tool where now all of a sudden, now we need additional money for food and housing. The trust can't pay for it because it would reduce our benefit. So why don't we just distribute? So the trustee takes money, puts it into the ABLE account, and now the ABLE account pays for food and housing. So it's a huge loophole. It's been there. It was talked about when the ABLE account, was being discussed in Congress. They never did anything with it. They haven't done anything with it yet. It just becomes a huge loophole where it gives us flexibility on the back end. So we really do want to keep the bare minimum in there, but it really does become an effective tool on the back end to get around essentially the restrictions on a supplemental needs trust. And also what I really like about the ABLE account is the independence that you can provide to your child. I know one of the guys that I actually went and listened to, he's based out of California, and his practice is devoted solely to this. And it really was, California was one of the first states to actually allow, the debit card, the credit card concept, where Arizona is just getting there. But he was explaining like just how really neat it was, because now parents can put money on that type of an account. Now their children can go to the movies, go out to restaurants, and they just have that independence. And so I certainly can see where that could be an effective tool, but just keeping in mind, we want to keep a bare minimum in there because of it being subject to the state.
Well, thank you so much. That's really great idea. And as we're trying to figure out now too, with our son being a teenager, I being here in California, didn't even realize that we could possibly have some sort of a debit card or something for him to be able to use to start to teach those, I guess, life skills. So I appreciate knowing that too. You know, you just kind of go along with things day by day, or as parents, some of you that have younger children, you know, it gets tough and you're trying to do all your different appointments that you're doing and working. And now, you know, with being at home more, and you start to forget what our kids are going to need in the future. So I really appreciate it. And thank you for that insight.
Jeff, is it up to 18,000? You know, I'm not thrilled about the ABLE accounts, but my thought was it's up to 18,000 per year they could put into it. And if they wanted to put it towards buying a house or buying something, is that the amount that they can put into it per year?
Yeah, right now it's capped at.
You froze up. Jenny, he froze up.
I believe that's okay. There you go. It's his Wi-Fi.
Okay, so are you froze up? Can you say that again, Jeff?
Oh, sorry. So yeah, so the maximum annual contribution right now is tied to the gift tax exclusion. And so yeah, at this point it would be $15,000 per year.
Oh, 15. Okay. And when you were saying that about a debit card, like I just give David my debit card. That's probably not smart, but oh well. Okay, well, these are some, I hadn't thought of those things, and he likes using my debit card, but all right. And I'm sure there might be other parents, so I'll be quiet. Anyone else would like to ask Jeff a question?